Olá pessoal, boa tarde. Começa agora mais um ITS ao vivo. Eu estou aqui com a Giovana e a Amy, daqui a pouco eu vou dar um espaço para ela se apresentar. E hoje a gente vai falar sobre os vetos presidenciais, a ANP, da Lei Geral de Proteção de Dados. E vamos fazer uma comparação também da LGPD, da aplicação, da redação que tende a ser final, da LGPD com a GDPR. E vamos discutir alguns pontos sobre esses vetos, o que de ruim que aconteceu, as nossas opiniões. Vamos começar agora falando também sobre os cursos. Não temos muitos cursos para falar dessa vez, a gente vai falar só sobre a International School São Paulo, que ainda está com inscrições abertas. Todo mundo do ITS vai estar lá, menos a Priscilla. Eu mesma não vou estar, uma pena. Eu queria estar, mas não vou poder mais. A Giovana e a Amy, inclusive, vão estar lá. E, bom, a gente também vamos falar as notícias da semana, né, Gi? A gente teve essa semana... entrou em vigência, a lei do cadastro positivo, que tem algumas discussões ali que tangenciam também proteção de dados, porque na verdade a lei de cadastro positivo ela vai um pouco contra a LGPD, justamente porque ela não prevê a questão do consentimento.
Isso, a gente já tinha uma lei, na verdade, que previa o cadastro positivo desses bons pagadores, mas era uma coisa que você, bom pagador, tinha que se cadastrar naquela base de dados.
Tinha que fazer o opt-in.
Exatamente, ou seja, você teria que expressamente consentir e querer estar ali naquela lista, que, enfim, depois é compartilhada e vista por instituições financeiras e por outros agentes que fazem parte desse ecossistema de pagamentos. E por essa nova lei, esse banco de dados é criado automaticamente, como acontece no cadastro negativo dos maus pagadores. Então acontece uma inserção sem um consentimento, seja expresso ou não, da pessoa, do cidadão. Você até pode depois dizer, por essa nova lei do cadastro positivo, que você quer sair do banco de dados e não estar mais ali, mas você não teve uma análise de consentimento prévia à inserção do usuário naquele banco de dados.
Isso aí. E aí, essa é a notícia da semana, acho que mais importante que a gente tem. Vamos ver se as pessoas estão entrando. A gente logo já vai começar com o nosso
mais importante,
principal.
Exato, mais importante vírgula, da semana.
O mais importante da semana, sem ser o nosso tema principal. Verdade.
Que é o justamente dos vetos ao texto final, vamos dizer assim, da LGPD. Mas a gente nem pode dizer que é o texto final, porque esses vetos ainda podem ser novamente analisados pela Câmara e pelo Senado. A gente não tem como dizer se vão ser ou se não vão ser, mas a gente pode ainda ter outra alteração no texto da LGPD. E a gente vem vendo essas alterações desde dezembro, Tá sendo um vai e volta infinito.
Essa, inclusive, é uma das críticas, que as questões estão indo e voltando a todo momento. Então, agora eu vou mudar para inglês. A nossa live vai ser em inglês, justamente para que a Amy possa nos entender. So, now let's switch to English. Amy, can you introduce yourself, please?
Yes, thank you. So I'm Amy, I'm a cybersecurity researcher and PhD student from the UK, and I'm the ITS Data Protection Fellow this summer. So I'm spending 6 weeks here looking at data protection issues, looking at the data protection framework that's coming through in Brazil and comparing it to GDPR and the regulation we have in the UK.
Awesome, thank you very much for being with us today.
Thank you for having me.
And please let your comments below in the live so we can exchange information and comments and answer your question if we might know. And let's start with the first veto, which is about the human revision. The human revision is now revoked for now. It's vetoed. But it was vetoed by the president, so now an automatic decision, we don't need human revision anymore. So what it is different from GDPR in this sense?
Well, there are a few relevant articles in GDPR that relate to the right to an explanation and talk about automated decision making. So in particular, Articles 12, 13 and 22 all relate to the right of explanation and transparency in automated data processes. And in particular, Article 22 talks about the right that data subjects have not to be subject to legal decisions or legal consequences solely based on automated decision making. And that includes profiling as well, so data that's used without your consent to profile you. And there are several implications for this. So if your data processing falls under this automated, fully automated process, you are required in GDPR to let the data subject know that this is happening, give them the right to intervene or to challenge a decision, and also have a mechanism in place to check that your automated decision-making system, so your algorithm, is actually performing as it's intended. So I'm quite interested in this veto because it seems to take away one method of checking that an algorithm is working. Without some human oversight of what the algorithm is doing, you not only take away this form of verification that this algorithm is making the right decisions or isn't doing something that's undesirable, but you also take away this right to explainability on behalf of the data subject, and therefore the right to challenge your decision or understand what the algorithm's actually doing. So that's GDPR and its coverage. It is slightly vague and there are some exceptions. So where a process is semi-automated, for example, it doesn't apply, or if the data subject has given explicit consent, it doesn't apply, and it's still quite hard to put in practice, but it is there in GDPR.
Yeah, and one of the arguments of the presidency, one of the presidency's argument on this veto was that startups and also other enterprises could be could have a problem and affected by guaranteeing this revision making by a neutral person. Do you think that this is I don't know. We know that this is an argument that has been made everywhere, but so what's your opinion about this?
I can see the point they're trying to make. It is a burden, and it would be a really difficult process to put in place to say that there needs to be some form of human audit on algorithms, especially in the startup space, which is incredibly fast moving, and scrutiny would slow them down. But that's not to say that you shouldn't have this oversight at all. I think the potential costs to data subjects can be really huge from a kind of system which makes decisions about them without their consent, which could be legal decisions, it could be decisions that pertain to public services, so really quite essential. So I think you have to take that into consideration as well, and weigh it up to really justify some sort of oversight. I think some sort of oversight is warranted.
Yes. And what is quite funny is the justification is based on the principle of public interest. So it's quite forced.
I'm not too convinced. I think the argument is based on corporate interests. I think public interest, and I think this is a message that comes through from civic rights organisations and civic advocacy groups as well, is that you want more transparency. You do want humans involved in these decisions because they affect humans.
And I think the law could modulate in other ways the effect that a data protection law can have in startups, or even the national authority could modulate it in a way that it would not suffocate startups and new enterprises to come on.
Yeah, definitely.
So, that's our comments for the human revision. Now for the veto for the suspension and prohibition of the use of database in case of violation. We not have a comparison in this sense.
Not so much. If we look at data protection authorities under GDPR, a lot of the powers of enforcement they have is related to fines. So in terms of sanctions relating to databases, there might be misusing data or be processing data without consent. That would probably be dealt through maybe other mechanisms like law enforcement. So definitely some open questions with this vetos.
Yeah. And like and again the presidency's argument, which we think, I mean, just to not be repetitive, but we think that they are important to mention, so we can really understand why those vetos were happening. Because this one is a quite interesting one, because they are saying that if you are blocking this database, for example, you could then block the like the giving of public services or the right working of public services.
Yeah, I think
Which might or might, I don't know.
it's true, I suppose. So if it turns out that a database or a data controller hasn't been using data correctly, there is the risk that if you just revoke access to the database, you could damage healthcare provision or essential public services. But in that case, could you not still have the option of enforcing this as a sanction with exceptions for critical infrastructure or essential services?
And actually this was like the original text of the law is the sanction is an option together with a fine, for example. Is an option for the authority to give this as a sanction. So so if we have like a specialized authority, then they could measure if this would be a due sanction or not. Right?
Yeah, check up.
So this could be an option, because if you have a private company, then you don't really have like a total private company which is not helping in self-care or in any public service, then we would not be violating any public service. Right?
Yeah, there are definitely cases where you could suspend a database and it wouldn't cause a negative impact to society and citizens or wide negative consequence.
Yeah, I think we can see from the next ones that the independence in the choice of the authority is like reducing, so it's bad. So the next one we have is about the DPO. Now the DPO doesn't need to have legal knowledge. So what's about for the GDPR?
So GDPR does say that the DPO needs to have an expert knowledge of data protection and regulation and practices. So it strongly implies that it should be a lawyer or an auditor or someone who has that sort of data protection expertise. And within the tasks that a DPO is required to do, as listed by GDPR, it includes doing data protection impact assessments, handling data subject requests, and actually one of the tasks is maintaining expert knowledge in this area. So GDPR seems to have this requirement. It doesn't list a particular exam or a particular qualification.
A certification for that? No,
but it definitely has the
general legal knowledge. So
you should have the expertise for what you're in control of and what you're responsible for. So this is interesting. This veto, I think.
Yeah, let's see about the liability in this sense.
Exactly, because it would be extremely interesting to hold a DPO liable for something that they are not qualified to understand.
Yes.
So it'll be interesting to see how this happens in practice.
And in the end, if they are calling themselves a DPO, then they should be qualified for what they're doing, right?
Exactly. Yeah.
Yeah. Is there any justification for that?
Yes, they are saying. So, wait a second.
Oh, we have some comments too. Let me see. So, check the. Será que esses vetos na LGPD impedem que as empresas brasileiras acessem o mercado europeu? Vinicius says that he's wondering if these vetoes are blocking the Brazilian enterprise to access the European market. And so, since LGPD now is quite different from GDPR, the compliance and
So as far as I understand it, and correct me if I'm wrong, but a lot of the principles and a lot of the regulation between GDPR and the Brazilian data protection regulation are equivalent, and there is still a lot of shared regulation and shared content. But yeah, it really depends on what happens in the next year and how much does change. And he's right, that increases the burden of compliance. The more the sets of regulations diverge, the harder it is for a multinational corporation to operate.
Yes, and in the DPO case, like if, I don't know, very hypothetical situation, but couldn't the European Union or like a specific country find that if the DPOs are not available or are not prepared enough to make the data protection assessment, then that the whole system would be kind of biased or, I don't know, ineffective here in Brazil?
So yeah, I think there is an interesting point, I suppose, when it comes to trusting the strength of the regulation and the effectiveness of the regulation. And I came across an interesting point recently talking about adequacy decisions and data sharing between the EU and states that follow GDPR and other states. And right now Brazil is not one of the states that has adequacy status, so to enable personal data transfer out of the EU into Brazil, unlike Canada and so on. Uruguay, I think, has it as well. So it would be a goal of this regulation and sort of data protection in general within Brazil to achieve that status, to facilitate that data transfer. So yes, you really do want to kind of reach that threshold. Because not reaching that threshold indicates a kind of lack of trust in that sense.
Yes, sure. And there also comment asking if in Europe all the DPOs are lawyers. All of them are lawyers.
They don't need to be lawyers, so I suspect not all of them are lawyers, but certainly the legal expertise is ideal for the role of DPO. If they are doing something like internal audit as well, if they're an expert professional auditor, they'll also be eligible and suitable for the role.
Paralegal, something like that.
Something like that.
So they could be inside the organization or also hired, like from outside. Right?
Yeah.
To audit, like external audit.
Law would make you well, but audit also.
Okay. Do you want to just say about the justification?
This one is the best one, or the worst one. I'm sorry, but I mean, it's saying that it is against, or like to enforce that the DPO has this legal knowledge, this legal background is against the public interest, because it is a very excessive requirement that reflects in the unnecessary interference by the state in how the enterprise's structure will be. But in fact, here, like, the state would only be requiring that the enterprises or the organizations have like someone to take care and to make the assessment of the data protection. So we could laugh about it.
Yeah. Interesting.
Yeah. So the next one is the most weird one. It's about the collection of fees for the service of a source of funds of the national authority. So basically, they say that national authority is not allowed to collect fees anymore, but we're not sure what fees they are talking about, what services they are talking about. Bruno Bioni commented in an interview that the national authority could give an opinion, for the enterprise, but we are not sure what kind of opinion could be for and which requires some fees. So we're not sure about that. It's quite a little bit weird.
It is, yeah. I think when I look at the UK and the way that we've implemented data protection regulation, our Data Protection Authority, the Information Commissioner's Office, it does have a fee-based system, but that's not required by GDPR. GDPR doesn't mandate any fee-based system. It says, data processing companies just manage themselves. They don't need to pay a fee to register or anything like that. The reason that the UK has this fee-based structure in place is just because that's what it had before for pre-existing regulations from the 1980s. And now that makes up about 90% of its funding. So taking away the fee would have caused a catastrophe in the UK regulatory system. So that's the reason we have it. It's just an overhang, so you don't need it. But it does raise questions about where funding does come from. So I guess primarily the state in this case.
Experts says that the government now, it's the only one allowed to give some sources to the authority. So that also raises some questions about the independence of the authority.
Definitely. In terms of, I mean, there are other states that do receive, where the Data Protection Authority receives their funding from the state. So France is one example, where it comes from the Republic. But I think this is one of those vetoes and those particular aspects where I'll be interested to see what happens over the next 2 years, to do with the nature of the AMPD and the authority in Brazil and how dependent it can be. And funding does affect that, so be interesting to see exactly, like you said, what it means by fees, what it means by services. The options available to the authority for different kinds of, whether they can take donations, whether they can take different grants, and what options are available for them.
Whether the donations would be enough to keep the authority independent, which probably wouldn't, right? And the ICO, you commented that the main form of budget from the ICO are the fees that...
Yes, so 2018-2019 figures, the income for the ICO was about £43 million. So just under 200 million reals, and 40 of that, so 40 out of 43, came from fees, and the other 3 came from a government department grant. So really the vast majority comes from the fee that every organisation or sole trader that's processing data in the UK pays to the ICO, and that has different bags. If they've got fewer than 10 people, it's about £40. If they've got over 250 people or over 36 million turnover, it's almost £3,000.
So that's a fee, not a fine.
Just a fee, an annual payment that you make every year to register yourself as a data processor.
Okay. So the last one is about, it's a prohibition for the public sector that now, it's now the public sector can share personal data with private companies, changing from the first text about the prohibition. Now they can. What different is it from? From the GDPR?
Actually, I found this quite interesting. I'm not too sure because I think I want to know more about the kind of protections that are in place and how it aligns with the rest of the data protection regulation. In terms of the UK, there are mechanisms in place to share data. So for example, potentially not core government data, but our National Health Service shares data with technology companies using, harnessing the power of AI in healthcare, but under very strict mechanisms that the ICO does have oversight over and changes. So it is enabled. So my question with this veto is, if you can share personal data from the private sector to the public sector, what controls are in place? Are you still adhering to the rest of the principles that exist within regulations like GDPR? I'm interested as to what it will look like.
Yeah.
So I think it's that the law is making the requirement of this data transfer being provided in public-private contract, or like that. This transfer would be in line with the public interest. I mean, this was the requirement. And this requirement was established, like so that this data transfer would be would happen. But then they were changing also this provision.
Yes, I think the key interest I have in this is what protections are there for the data subjects, for the people who are having their data being shared. How do you ensure that data is shared only when it's necessary to share it, in line with GDPR principles, that it's anonymized as appropriate, that sensitive personal data is not shared insecurely or without a legitimate purpose. So I don't know if that's answered anywhere. I don't think the justification for the veto answers it.
Yeah. I don't think so.
It doesn't say.
Yeah, it only says that it is it generates legal instability, insegurança jurídica in Portuguese, because in some activities you do need the data transfer between public, naturally public enterprises and private ones. Like for example, they were citing the Sistema de Previdência Social, the INSS, which is our retirement system, because it's kind of administered by a company which has a private nature, and also the national finance system, because it would also require a data transfer between a public and a private entity.
That makes sense. I think there are definitely cases where it's an advantage to be able to share this data. Just need to do it in the right way.
Yeah, we don't know the limits.
And I think in almost every case where the national interest has been referred to as justification, I think you can make exactly the same counter argument about how the national interest, the public interest, could be met by adhering to these aspects.
Yeah, the door's open. So.
You can argue anything, but I imagine advocacy groups would rather see those protections on
because
paper.
The protection or the requirement of being inside the public interest and everything is still in the law. This was not taken.
Exactly. So I think that's the main question I would have.
So let's see next chapters.
Let's see.
I think that is it for today. And thank you, Amy, for being with us.
Thank you for having me.
Amazing. Obrigada, pessoal. E a gente se vê, eu não, mas todo mundo do ITS se vê na International School São Paulo. Até lá, até a próxima.
Tchau.